Krista, are we live?
Yes, sir.
All right, let's go ahead and proceed. Oh, do we want to go on the record for this, Ms. Forrester?
Yes, please.
Let's go on the record on cause number DC 203975. Council, make your appearances.
Joshua Hancock here on behalf of plaintiff Brenda Lewis.
And Hope Zimlick Miranda here on behalf of Fiesta.
All right. Let's proceed.
Your Honor, we're here on a pretty simple motion to strike. Plaintiff has filed two separate notices to file affidavits pursuant to section 18.001 of the Civil Practice and Remedies Code. Both of those filings were untimely and several months past the deadline that's prescribed by the statute. I believe the first one was the actual deadline for plaintiff to file would have been August 6th of 2020. The first notice of
Is this under the new law?
Yes, Your Honor. It would be under the.
I think this is the first time anyone ever has tried to argue this, so it's kind of interesting. Okay, let's see how this all pans out. Okay.
Yep. So under the new section that went into effect on September 1st of 2019, which would have been, essentially a year prior to plaintiff's filing of affidavits in this case, it provides that the party offering the affidavit must serve a copy of the affidavit on each other party to the case by the earlier of 90 days after defendant files an answer. The date the offering party must designate an expert under a court order, or the date that the offering party must designate an expert witness pursuant to the Texas Rules of Civil Procedure. So the earlier of those three would have been 90 days from the date that defendant filed its answer, which would have been August 6th of 2020. And the language in that statute it outlines it in a mandatory sense, stating that it must serve by that deadline. As I mentioned earlier, plaintiff filed two separate notices with two separate groups of affidavits. The first one was filed November 25th of 2020. So that would have been over 3 months after the deadline. The second notice was filed March 2nd of 2021. And which would have been over 6 months past the deadline. And I think it's important to note plaintiff in her response outlines some alleged issues in obtaining affidavits from various medical providers. However, plaintiff never sought an extension from us, never sought a Rule 11 agreement to request additional time to file the affidavit. So we were never made aware of any alleged issue that plaintiff was having in obtaining, the desired medical or billing affidavits. And I think it's important to note that for instance, the notice of filing affidavits that was filed in November of 2020 contained 9 affidavits. 8 out of the 9 of those were dated in September of 2020. They were dated and notarized in September of 2020, several weeks before plaintiff's filing deadline would have been. Plaintiff has provided no explanation as to why affidavits that were dated prior to their deadline could not be timely filed. And as it currently stands, we have mediation scheduled in a week. We have pretrial materials due in about 5 weeks, and we're set for trial at the beginning of December. So at this late in the game, after expert deadlines have passed, to require my client to go and find experts to controvert the records would impose a great cost to my client. when when plaintiff has provided really no reasonable basis for why those were not timely filed.
Response? Mr. Hancock?
Sorry, it's on mute, Your Honor. Yes, Your Honor, we don't dispute the facts that if you look at the exact language of section 18001 that we did file our affidavits past the proposed deadline, but plaintiffs argue here. I mean, again, I don't see how defendant is going to be prejudiced by this at any means. Again, we don't have trials. The next trial setting is in this December 7th. As Your Honor, I'm sure is well aware, is under section 18001I, even if notwithstanding a deadline under section 18001 may be altered with leave of the court. If it's down to defense counsel having to hire experts to controvert these bills, even though we're past the deadline, we'd be willing to work with defense counsel to keep the deadline open. I know that Royale, the assigned attorney, reached out to her whenever defense counsel filed their motion to strike our counter affidavits, agreeing to extend the deadline for them to controvert. Again, I don't feel that the purpose of 18001 was to prejudice plaintiffs if we didn't file timely. Albeit exactly why 18001I was implemented was because with leave of the court, it permits us to file them lately, if you would allow it, Your Honor.
Yeah, I will allow leave, but I do want to be fair to the other side. Did you want more time to file your counter affidavit, or did you want to file a counter affidavit?
Yes, I mean, we likely will. So yes, Your Honor, we would like more time to do so. Like I mentioned, we're scheduled to mediate the case on October 15th. So, for all practical purposes, it might be a moot point after that date. But I would like my client not to be put in a position where, we're having to incur all of these fees a week before mediation, when.
What if we did this? I want to be fair to both sides. So what if we move the trial setting to May and gave you until January, early January, or not, it doesn't have to be May, March, or April, or May, and gave you until January to file your counter affidavits?
That would work, Your Honor.
No objections, Your Honor.
When do you want to reset the trial, Ms. Forrester?
I think
Is your name Ms. Forrester? It says Mark Forrester.
it's not, Your Honor. It's Hope Miranda. Mark Forrester is my paralegal.
Oh, okay.
I'm not entirely sure why it's showing up with his name on here, but yes, anytime in April or May works for us.
Mr. Hancock?
Yeah, I don't, anytime in April and May works for us as well, Your Honor.
Okay, so Ms. Miranda, is that what you said, Ms. Miranda?
Yes, Your Honor.
Let's go ahead and reset this trial. Just prepare an order for us. Why don't we set the trial on May 17th? Does that work?
Yes, that's fine. That's fine on our.
And then we're going to grant leave. The court's going to deny the motion, grant leave to file these, and give you until January 10th to file counter affidavits.
Okay. And would you like for us to prepare and submit that order for you to sign?
Yeah, so what I'd like you to do is go ahead and prepare the order. On the order, say that the order was signed or the hearing was held on October 4th, 2021. Go ahead and share that with Mr. Hancock, and then send it to the court coordinator, Rhonda, my court coordinator, as well as e-file it.
Okay, will do.
All right, anything else, guys?
No, Your Honor.
No, Your Honor.
Great, you guys be safe.
All right, thank you.
Thank you. Krista, did you get a chance to read any of that stuff?
I've been looking over it, yes.
What do you think?
I think it's gonna be interesting.
Yeah, I think it will be too. It should be interesting. So it's anyway, one of those things that you don't think you really see in real life, but
Right.
you see in real life. So all right. Well, I will